State to file an amended charging document reflecting these amendments. We will proceed to sentencing at this time.
State of Kansas versus George Brennan Marshall begins with a major shift. Felony criminal threat charges reduced to misdemeanors before the plea even enters. That tells you negotiations were serious. But the threats against his own family remain disturbing. What pushed this case here? Subscribe for more dramatic breakdowns.
State of Kansas versus George Brennan Marshall. It's case number 2025 CR 509. Mr. Marshall appears from the Butler County Detention Facility's Zoom location. Joseph Favre appears as defense counsel. Cheryl Pierce on behalf of the state of Kansas. This matter is scheduled to come before the court at this time for arraignment, pursuant to proceedings held on January 30 before Pro Tem Judge Kristen Hutchison. At that time, prelim was waived, announced that plea was likely, arraignment set for today. Mr. Favre, does your client desire the charging document to be read to him?
No, Judge. He would waive a formal reading today, and we're ready to proceed with a plea.
Very well. Please state for the record what you believe the plea agreement to be.
Yes, Judge. So the state will be amending counts 1 and 2 from level 9 criminal threat to misdemeanor assault class C each. Mr. Marshall will be pleading no contest to amended count 1 and 2, as well as counts 3 and 4 as currently charged, which is misdemeanor theft class A, criminal damage to property class B, both of those being non-person. And then we have joint recommendations for a sentence.
Very well. Ms. Pierce, has Mr. Favre announced consistently with your understanding as to how this Marshall case would be handled?
Yes.
Very well. Most importantly, Mr. Marshall, your attorneys announced that you would now resolve this case and accept conviction for an amended charge in count 1, assault, a class C misdemeanor, count 2, assault, a class C misdemeanor, count 3, theft, a class A misdemeanor, and count 4, criminal damage to property, a class B misdemeanor. Is that indeed your intention?
That's correct, Your Honor.
You understand that the class C misdemeanors that the assault charges would represent are punishable by up to a $500 fine and up to 30 days in the county jail or both. You understand that?
I understand.
And that the theft class A misdemeanor in count 3 is punishable by up to a $2,500 fine and up to 1 year in the county jail or both. You understand that?
I understand.
And that count 4, criminal damage to property, would be a class B misdemeanor, punishable by up to 6 months in the county jail and up to a $1,000 fine or both. Do you understand that?
Yes, I understand.
Right. And you're attempting to enter a no contest plea at this time, Mr. Marshall?
Yes, Your Honor.
I would ask the state to provide a concise statement of factual basis for each of the 4 charges.
Yes, Your Honor. So on November the 19th of 2025, law enforcement officer Patrick McMurphy with the Benton Police Department was dispatched to 110 West Littston Street in Benton for a report of criminal threat and theft. Officer McMurphy met with Dennis Lang, who reported that Mr. Marshall had been texting him and his wife, Mary Marsmay Perry, who is the defendant's mother. There were photographs that were shown to law enforcement of a electric meter that had been removed from a storage unit there in Benton on Southwest 20th. It belonged to the storage unit would belong to Miss Perry, and Mr. Marshall had taken that meter away from the building without permission to do so. I would note for the court that Mr. Lang and Miss Perry live together and are in a relationship. The threats included threats that Mr. Marshall was going to hurt Mr. Lang and Miss Perry, basically saying things like, if I have to, I swear to God, I'll kill you. George also wrote that, okay, I will start destroying everything you own. last time I remember I was lenient and I broke all the windows. I will break all the windows this time. Indicated that shit will get real bloody. I'm at the point where I'm going to make Dennis and Mom disappear. Also, it was reported that Ashley Marshall, who is the defendant's sister, reported that on November the 15th, that she had received some text messages from the defendant as well. Some of those are that my side will take your side down in a heartbeat. My team doesn't lose. If you want war, you got it, Ashley. I will kill you. 3572 Dome. Either chill or it will happen, Your Honor. Both of these, or all three of these individuals, were in fact placed in fear or apprehension of bodily harm. Also, as to the theft, that is the meter that was removed from the storage unit without permission from Miss Perry or Mr. Lang. That was in the defendant's home. The criminal damage to the property also involved the electric meter, in that he had to remove it from the building, destroying parts of it, damaging it as well, Your Honor.
Right. One question, Ms. Pierce, would the state's evidence reflect that when the electric meter was taken, it was done with the intention to permanently deprive the owners of the benefit of that property?
Yes, sir, Your Honor.
Thank you. All right, so Mr. Marshall, do you now enter pleas of no contest and accept conviction for 2 counts of Class C misdemeanor assault, 1 count of Class B misdemeanor criminal damage to property, and 1 count of Class A theft in this case?
Yes, Your Honor.
Very well. Court finds that Mr. Marshall's pleas are a free and voluntary act on his part. There's a factual basis supporting each charge, and he's been made aware by the court of the possible penalties connected with any conviction for these offenses. The court does accept the defendant's no contest pleas and finds George Brennan Marshall guilty of, in count 1, Class C misdemeanor assault; in count 2, Class C misdemeanor assault; in count 3, theft, a Class A misdemeanor; and in count 4, criminal damage to property, a Class B misdemeanor. We would ask the state to file an amended charging document reflecting these amendments. We will proceed to sentencing at this time. Ms. Pierce, what are the state's recommendations regarding an appropriate sentence for Mr. Marshall?
So, Judge, with regard to the assault, 215412A, that is a Class C, that's 30 days in the county jail. That would apply to count 2 as well. The theft is a Class A, that would be 12 months in Butler County Jail. And count 4 would be 6 months in the Butler County Jail, and that would be the recommendation with regard to the sentencing, the underlying sentencing of all of these counts. The state would ask for and we have agreed on a term of probation of 36 months. We have also discussed that count 3 and 4 would run consecutive to one another, and counts 1 and 2 would run concurrent to 3 and 4.
Now we're in the heart of sentencing strategy. Consecutive time on theft and damage creates an 18-month controlling sentence, but probation for 36 months shifts the focus to rehabilitation, mental health treatment, inpatient drug programs, sober living. This is structured intervention. The real question, will he comply?
As part of his probation, he needs to have a mental health assessment and be actively involved, participating on a regular basis with mental health. He also needs to be assessed if qualified in inpatient drug treatment. And once released to that, some type of sober living if he qualifies for the same. And then again, as I indicated, at least until he is involved in mental health and inpatient treatment, I would not recommend any contact with the victims in this case until he's gotten some of that treatment under his belt.
How would Mr. Marshall know under this scenario that he's free to have contact with these individuals?
Well, I think that as part of his probation, the probation officer can, in fact, contact those victims and ask them. Miss Perry, his mother, has always been very involved with Mr. Marshall and his probation and those things. So I don't think that she would. I think she would participate in that if she felt that it was time for contact. I think she would be. She would assist or she would help with probation with that.
All right. Thank you, Ms. Pierce. Anything further?
No. Other than to
Fabre.
include all
Right.
other conditions of probation, Your Honor. I don't have any information as to any kind of restitution, Judge. There was never any claim for that, so I'm not asking for that.
Very well. Mr. Favre, your recommendations regarding an appropriate sentence.
But Judge, these are joint recommendations, and they are a little bit out of the ordinary. The length of the probation recommended, and some of the terms. But as Ms. Pierce noted, the main victim is Mr. Marshall's mother, and this is part of what she had requested, and we think that it's really at its heart a substance abuse and probably more than anything else a mental health issue. So Mr. Marshall has plans to go to inpatient treatment at Mir in Sedgwick. He's already talked to them about attending inpatient treatment there. He also is going to be living, obviously not with his mother, with some friends of his that he believes will be a good sober influence. So when he's released, so we think these are appropriate. We would ask the court, given the fact that he's been in custody for this length of time, and also given that he's going to be hopefully entering inpatient very soon, to consider waiving his attorney's and application fee.
How much would your fees be for the representation of this client?
$1,100, Judge.
Thank you. Just a
Judge,
moment, counsel.
Can I inquire?
Go ahead.
I just inquire as to if he's been in contact with Mears? Is there a bed available now or not?
I don't know that answer.
Mr. Marshall, at this time, the court will address you personally, and I'll ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court.
Yeah, I would like to say something.
Go ahead.
No, I've been here and reflected on my actions and have gone through a lot of guilt and remorse for what I've done towards my family, and I really want to get my mental health in check and my sobriety in order. So the sentence is something that I kind of agree with, and I've been to inpatient before, and I'm going to go this time and take it a little more serious and gain a network of people in my life that'll, help me with my sobriety. That's something I've never done before. So being involved with AA or NA is something that I want to take serious. And yeah, that's all I have. That's all I have to say.
All right. Thank you, Mr. Marshall.
Judge, if I could just say one more thing, I apologize for interjecting before you pronounce sentence.
Go ahead.
Thank you. Miss Perry's mother just messaged me. Apparently, she's watching the live stream, and she wanted to say that she's very supportive and that she has been talking to Mir. They're going to contact her, and she'll let the probation officer know when there's a bed available. She's very supportive of George. She loves him unconditionally and thinks he can change his life. So she wanted me to pass that on.
We all appreciate that. Mr. Favre, thank you for sharing that information. Very well. The court is prepared to announce sentence in the Marshall case at this time. For the offense of assault in count 1, the court imposes 30 days in the Butler County Jail. For the assault conviction in count 2, the court imposes 30 days in the Butler County Jail. On count 3, for the theft conviction, a Class A misdemeanor, the court imposes 12 months in the Butler County Jail. And on count 4, criminal damage to property, the court imposes 6 months in the Butler County Jail. The court runs the time on counts 3 and 4 consecutively with one another for a controlling sentence of 18 months in the Butler County Jail. The time imposed on counts 1 and 2 are run concurrently with the time imposed on counts 3 and 4. So the controlling sentence in the case is 18 months in jail in this case. The court at this time does grant the defendant probation for an initial period of 2 years.
Here's the pivotal moment. The judge locks in 18 months but suspends it for probation. Strict conditions follow: mandatory mental health assessment, inpatient treatment, sober living, and absolute no contact with Dennis Lang, Mary Perry, and Ashley Marshall. This isn't freedom, it's conditional mercy tied directly to rehabilitation.
At least as an initial term, with conditions, including that the defendant immediately or as soon as possible obtain a mental health assessment and abide by provider recommendations, including medication management. Further, it's the court's understanding that it's the intention of the defendant to immediately enter into the first available bed for inpatient drug treatment. The court will order him into drug treatment at this time as soon as possible to enter a program, and then to follow that up with a sober living component. If he qualifies for such a program, then he must participate in that. The defendant is ordered to have no contact at this time with any of the victims in this case. I think they've already been identified of record, but I want the record to reflect again that at this time, Mr. Marshall is not to have contact with Dennis Lang, Mary Perry, or Ashley Marshall. The court will delegate to his supervising court services officer the authority to allow him to be relieved from the no contact requirement after he's met sufficient conditions regarding rehabilitation that officer believes that that contact can be done safely. And obviously there would be a component in that the court services officer would essentially get the input from the family members or other protected persons under this order before allowing contact between Mr. Marshall and those individuals. If you're allowed to have contact at some point, Mr. Marshall, it has to be peaceful and non-harassing and no problems, and can't go beyond what they want to have as far as contact with you. But I hope at some point in the future, they're willing to have liberal contact with you. But for now, we're going to have you work on yourself before the court allows contact with them. Do you have any questions about that, Mr. Marshall?
No, I completely understand it.
All right. The court will be assessing a misdemeanor docket fee, misdemeanor probation fee. Under the factual circumstances of this case, the court will waive all bids assessments, despite the obvious value that Mr. Favre's services has been to Mr. Marshall. The court will waive bids assessments, but will assess the docket and probation fees for a misdemeanor. There does not appear to be a request for restitution at this time. Certainly, counsel, I understand the joint recommendation for an initial 3-year period. However, the court is cognizant that there are some limitations on the court's legal authority and statutory authority on misdemeanors to impose an initial probation period of that length. Certainly, if the Court Services Department believes that Mr. Marshall still has unsatisfied requirements at the end of a 2-year period, they can seek an extension of his probation, and the court would encourage that if necessary. Mr. Marshall, I would hope that you can work on yourself and be in much better shape to be successful in the community within the 2-year period, which the court has established, perhaps even sooner. But I think you need to first get into this inpatient bed and get this mental health assessment either before or just after you complete that program, and then follow the recommendations of those providers about how you can make yourself better and perhaps control your temper better. Mr. Marshall, I am presuming today that you don't have other holds on you. Do you have holds from any other cases?
No, I don't.
Okay. Well, I'm going to order Mr. Marshall released at this time. However, Ms. Pierce, do you have a handle on his accrued jail time credit?
He came in on first appearance on 11/19, so I would say I don't know that he was picked up and put in custody on that date.
I think
Looks like he's got at least 98.
Yeah.
Looks like he's got at least 98 as of today.
I would say that's probably about right.
Okay. If your office could research that and include that in the journal entry which stems from today's proceedings, Ms.
Will
Pierce.
do.
You got a long way to go, though, to complete that sentence, Mr. Marshall, and hopefully you won't be back before the court to serve any more of it. Good luck, George. I hope everything's successful this time around, okay?
Thank you.
All right. Is there a representative from the jail in the room that's heard the court's release order?
Yes, Your Honor.
Okay. All right. And I hope you've got somewhere to go right away, Mr. Marshall. Do you?
Yes, I do.
Oh, okay. Just wanted to make sure. Do you know where you're going to be going right after you get released?
To Rise here in El Dorado. It's a church. They have beds available. And from there, I'm going to figure out what I'm going to do. I have 2 supportive sons that they're 18, but they're the least I want to ask for help. But yeah, I do got a plan.
Okay. All right, Mr. Marshall, they'll write this number down for you. I need you to contact Butler County Court Services tomorrow by phone. Can you do that?
Yeah.
I've already given
Area code 316-322-4153. That's Butler County Court Services. Check in with them tomorrow and then follow that office's direction about what you need to do next, okay?
Okay.
All right. Ms. Pierce, anything further the court needs to address?
No.
Mr. Favre?
Ms. Perry says that, I guess, I'm not sure if this is right. Your son, George, you have a son?
Yeah.
She says that your son can pick you up from jail and take you to Rise or wherever you need to go.
Okay,
So
perfect.
he's not one of the no contacted people, but so I guess that's the person you can call for a ride, and she'll make sure that happens. Okay.
Okay.
That's all. That's it.
All right. Very good. Thank you for suggesting that arrangement. If there's nothing further, then the George Brennan Marshall matter will currently be in recess, and this meeting may be ended for all at this time.
The judge releases Marshall immediately, credits nearly 98 days served, and sends him out with one warning: work on yourself. Contact court services tomorrow. Treatment starts now. This courtroom chose accountability with opportunity. Will he rebuild trust or return to jail? Like, comment, and subscribe for more shocking courtroom stories.